The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act with the purpose of making a state a two-way sanctuary state. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an amazing company. They're pro-freedom, pro-America. They support the Second Amendment. They also have amazing supplements and apparel. I use their supplements, quite often when I'm working out, the protein powder, the pre-workout, and also I wear their apparel quite often as well. So if you guys are interested, check them out. Again, amazing company, pro-freedom. And if you order something using my link down below and it's $50 or more, you can get a free 4-pack of energy drinks. In this video, we're going to be talking about a very significant Second Amendment protection case, which is once again back in front of the Supreme Court. This is a case dealing with a state's Second Amendment Preservation Act. We've discussed this case before because recently the Supreme Court issued an order denying a stay which would have protected Missouri's Second Amendment Preservation Act. After the denial of that order, this case was then sent back down to the 8th Circuit, who recently issued their decision in this case. The 8th Circuit sided with the then Biden administration and decided that the Missouri SAPA law was invalid in its entirety. But now Missouri has filed their official petition to the Supreme Court, and the Supreme Court will now consider in just 2 weeks whether they will grant review to this case and whether or not they're going to look at Second Amendment sanctuary issues. Now, for those not familiar, back in 2021, Missouri passed a law called the Second Amendment Preservation Act. The law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies and agents in their attempts to enforce federal laws, which in Missouri's eyes violated the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those inconsistent laws. The law also created a civil remedy where anyone can sue Missouri officials if they help to enforce a federal law that violated the Second Amendment. The Missouri law is similar in nature to the Texas abortion law, SB 8, and the recent Supreme Court ruling in the whole women's health case. With the Texas and Missouri laws and how they're structured, you can't get an umbrella injunction against the state or the attorney general since they're not actually the ones enforcing those laws. Instead, you would need to get a preliminary injunction or an injunction against every private individual who files these civil suits. In this Missouri case, the District Court on review ruled in favor of the Biden administration, striking down the Missouri Preservation Act in its entirety. Now, in response, the state of Missouri then appealed up to the 8th Circuit. Missouri asked for the 8th Circuit to stay the lower court's decision while the appeal was taking place. However, the 8th Circuit denied that stay and ruled in favor of the Biden administration. And that led Missouri for the first time to go to the Supreme Court on an emergency basis. They filed an emergency application and they wanted the Supreme Court to grant that stay. However, on review, the Supreme Court issued an 8-1 order denying that stay request by the state of Missouri. Only Justice Thomas was in favor of granting the stay in favor of the state. Now, after the Supreme Court's denial order in this case, it was then sent back down to the 8th Circuit, who then held expedited arguments and hearings in this case. Ultimately, the 8th Circuit ruled in favor of the federal government, once again, the Biden administration, striking down the SAPA law in its entirety. But now Missouri has filed their writ of cert to the Supreme Court, asking for the official review of this case on the final merits. In the petition, Missouri presents 3 main questions for the Supreme Court to answer in this case. First, can the federal courts second-guess a state's reason for exercising 10th Amendment authority? Second, does the Constitution prohibit states from exercising 10th Amendment authority when motivated by a concern that a federal statute is unconstitutional? And third, is the state official a proper defendant under Ex parte Young simply because the official is regulated by a statute? And does the official also need to possess authority to enforce the law? Missouri goes on to argue in the petition that before this case, it appears no federal court had ever blocked a state from exercising 10th Amendment authority simply because of the reason the state expressed for exercising that authority. The 8th Circuit did that here, striking down a state law solely because the act said that the legislator believes certain federal statutes are unconstitutional. The 8th Circuit's holding creates multiple circuit splits and is as wrong as it is unprecedented. It declared a Missouri law unconstitutional solely because of the law's legislative findings, specifically the legislator's opinion that some federal statutes are unconstitutional under the Second Amendment. The court took no issue with what the Missouri law does, only with the legislative findings and what they say. Indeed, the court agreed that a law with the same effect but different findings would be permissible. As the court put it, Missouri may lawfully withhold its assistance from federal law enforcement if it picks a different reason, such as withholding resources as a matter of policy rather than as a matter of constitutional interpretation. Now, one of the things that Missouri is pointing out here in their petition is that the 8th Circuit essentially said the structure and potential operation of this law is valid, but they ultimately struck it down because of its underlying Second Amendment purposes. Missouri argues that the 8th Circuit went against clear precedent and found that the state officials could be sued because the court believed that the state played a role in enforcement simply by complying with the state law. Essentially, the 8th Circuit found that compliance and non-action was actual enforcement, and therefore the state and the Attorney General could be sued in this challenge. Now, this law was originally opposed by the Biden administration, but now the Trump administration is in control of the government, obviously, and now they have the control of this case and what position they actually want to take in this challenge. Originally, the federal government here, the Trump administration, was set to file the reply brief to the Supreme Court on February 26th, but they received an extension. The Trump administration has now received multiple extensions in this case to determine essentially what they want to do and what two-way position do they want to take in this lawsuit. The Trump administration's response to this petition is now due on May 27th, so the administration will have to decide in just a couple weeks how they want to approach this challenge. One of the important aspects and kind of wrinkle in this case is that the petition was filed by the state of Missouri. So unlike prior Supreme Court petitions that were filed by the administration, they essentially don't have the option to just drop the case. So it's not like the Trump administration can just say, we're not going to challenge this or we're going to drop the petition because they're not the ones that actually filed it. Instead, they will have to respond to the petition in some way. I have no doubt that the 2A task force is taking a long look at this case and trying to come up with a pro-2A approach. Maybe there's some way where they can say, hey, we're not going to challenge this, that we agree that we shouldn't have brought this lawsuit. And yes, to the state of Missouri, you can have a SAPA law in place. How they do that, we're not sure yet, but this is one of those very interesting things, especially because the current U.S. Solicitor General was prior the attorney in Missouri who represented the state and Missouri's interest to protect the SAPA law. And so the current U.S. Solicitor General was in charge of this at the lower court levels, protecting the Missouri SAPA law. He was fighting against the Biden administration when the Biden administration was trying to override the SAPA law. So there's a lot going on here where you have, prior attorneys for Missouri in this specific case who are now at a higher level and are, essentially the U.S. Solicitor General. Now, at this point, the Supreme Court has given the Trump administration multiple extensions kind of based on the same reason. So at some point, the bill will come due and the United States government will have to respond to this petition. However, my general feeling from the Supreme Court may be that they don't want to take any high-profile 2A cases, and maybe they're going to let the Trump administration continue to kick this case down the road. Currently, we're still waiting to see how the Supreme Court wants to deal with other high-profile cases like the Snope rifle ban case and the Ocean State tactical magazine ban case that have been relisted multiple times to them, relisted again this week, and we're still waiting to see what the Supreme Court wants to do in those challenges. And even in those challenges, the clock is currently ticking because they need to grant review, and if they don't grant review before this term, it's going to be pushed out to next term, and I suspect that maybe something's going to happen maybe at the end of this term where you maybe have, the cleanup conferences, and hopefully, it doesn't get to that point, but even at the cleanup conferences, there is, a bunch of orders that can be issued after those conferences, and the hope would be that Supreme Court would grant review to those cases, and then essentially those cases would move forward during the Supreme Court's next term, so they could, kind of pull a fast one at the last second, grant review to those two cases, and then go on their summer break and let, all the anti-gunners freak out that the Supreme Court is taking a rifle and magazine ban case. So a lot is going on right now at the Supreme Court level, and a lot is going on with the 2A issues at large. We have a lot of challenges going on right now, not just, in multiple federal courts, state courts, cases pending in front of the Supreme Court. We have the executive taking a lot of actions in regards to the Second Amendment with the new task force. And then we have a ton of battles going on right now in front of Congress with the SBR and the suppressor issues. So a lot is moving right now. And, this is one of those critical cases that, is pending in front of the Supreme Court, but maybe the Trump administration is just trying to kick the can down the road because, they don't know how they want to handle this. They're kind of in a bad spot. Maybe they don't want to say states could, just put in place these types of SAPA laws. And maybe they're just going to try to kick this can down the road as much as possible if the Supreme Court would let them. So again, currently the Trump administration is set to respond to this petition in just 2 weeks, and we're going to see how this develops. And as things change, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.